Welcome back, class. Settle down, settle down. Today's explainer is basically your ultimate bar review cheat sheet for Rule 130. We're going to focus heavily on what makes evidence truly stand up in court. Whether you're actively prepping for your exams or you're just fascinated by how the legal system uncovers the truth, this session is going to make these complex rules crystal clear and, most importantly, highly memorable.
Here's our syllabus for today. We'll be covering direct versus circumstantial evidence, admitting object evidence, the original document rule, parole evidence and its exceptions, the rules for electronic evidence, and finally, weighing probative values. Let's get right into it.
Section 1. Direct versus circumstantial evidence. We're starting with the absolute fundamentals of proving a fact.
To put it simply, direct evidence hits the nail right on the head, right? No leaps of logic required. If a witness gets up and says, "I literally saw the defendant steal the car," boom, that's direct. You don't have to guess what happened. But circumstantial evidence, well, that indirectly proves a fact, which requires the court to connect the dots. Like, if a witness says, "I saw the defendant running away from the stolen car holding the keys," the judge has to actually draw the logical inference that the runner was the thief.
Now, here's the catch, especially in criminal cases. A single circumstance is never enough to send someone to jail. Because the standard is proof beyond a reasonable doubt, the rules strictly mandate that you need 2 or more proven circumstances to convict someone purely on circumstantial evidence. Those dots you're connecting, they have to logically point directly to the guilt of the accused, with zero room for doubt.
Moving from the theoretical realm of testimony into the physical world, we hit Section 2, admitting object evidence.
So object evidence, which you might also hear called real evidence, is anything addressed directly to the senses of the court. If the judge can actually see it, touch it, hear it, or, yes, even smell it, it counts. Think about a murder weapon, a blood-stained shirt, or even a specific scent. Like, if a blind witness recognizes a perpetrator by a very distinct cologne, that scent operates as object evidence directed right at the court's senses. Wild, right?
Now listen up, because if you want to pass the bar, you absolutely have to memorize these 6 strict requisites. You can't just whip out a surprise weapon in the middle of a trial like it's some dramatic TV show. First, it absolutely must be marked during pretrial. Second, actually presented in court. Third, identified or authenticated. Fourth, that authentication has to be done by a competent witness, someone with actual personal knowledge. Fifth, formally offered into evidence. And finally, number 6, the court must officially admit it. Miss even one of these steps and your crucial piece of evidence is completely worthless.
All right, Section 3, the original document rule. Let's pivot to paper. This used to be called the best evidence rule in older textbooks, but the golden rule here is incredibly simple. Yet, I promise you, it is constantly tested. If the subject of your inquiry is the actual contents of a document, you must present the original writing itself, period. You can't just stand there and talk about what a contract says. You have to show the judge the original paper.
But here's a curveball. I see this mistake all the time when I cold call students. I'll ask, are mere Xerox copies, just standard photocopies, admissible in court as an original? And everyone's first instinct is always to say no.
But the modern rules of evidence have actually evolved. Under the adopted Xerox rule, duplicates are treated precisely like an original. The burden basically shifts. A photocopy is totally admissible unless opposing counsel can raise a genuine question about the authenticity of the original or, demonstrate that it would be completely unfair to admit it, like if you only copied half the page and conveniently left out a crucial clause.
Moving right along to Section 4, parole evidence and exceptions.
This is the concept that ruins so many bar exams because students constantly confuse it with what we literally just talked about. Pay close attention to this vital distinction. The original document rule applies when the original is missing or its existence is totally disputed. But the parole evidence rule? That presupposes the original document is sitting right there on the judge's desk. The issue is that the parties have a written agreement, but one side is trying to bring in outside testimonial evidence to alter, add to, or modify the written terms. And the general rule is, absolutely not. The written word binds the parties.
But of course, the law is never entirely rigid, is it? You can't overturn a written agreement with mere testimonial evidence unless you manage to hit one of these 4 explicit exceptions. If there's an intrinsic ambiguity or a clear mistake in the writing, or if the agreement totally fails to express the true intent of the parties. You can also bypass it if the actual validity of the agreement is in question or if there were other terms agreed upon later. Just remember, these exceptions are your only way around the rule.
Section 5, rules for electronic evidence. Time to bring things into the 21st century. Let me pose a quick question to the class. Are your standard, everyday text messages or, say, CCTV footage from a street corner admissible as evidence in a modern trial?
The answer is a resounding yes. But just because they're admissible doesn't mean the judge is actually going to believe them. Their evidentiary weight relies heavily on these 6 specific factors. The court is going to heavily scrutinize the reliability of how the data was generated, stored, or communicated. They want to know how the originator was identified, the integrity of the information, how familiar the witness is with the system, the whole shebang. It's not just a free pass.
So the key takeaway here is that while electronic evidence is widely accepted, it's not invincible. The presumption of its validity can absolutely be overcome if opposing counsel proves that the source, the preparation, or the transmission is fundamentally untrustworthy. Like if a server was hacked or a phone's storage was compromised, that text message might carry literally 0 weight in court.
Oh, and beware of this classic Supreme Court trap. Note this down. A facsimile, a fax transmission, is not considered electronic evidence. Why? Because a fax literally creates a paper trail on the receiving end rather than an electronic data message. It's not the functional equivalent of an original under electronic rules. Do not let them trick you on that one.
All right, Section 6, Weighing Probative Values. We've reached the climax of our syllabus. I always teach my students this fundamental maxim when weighing evidence. Documents do not lie. Think about it. Humans, they might deceive you on the witness stand, right? Bias, memory lapses, just outright lying. But a contract, a receipt, a clear photograph, those are objective truths frozen in time. Looking at this matrix, you can really see how they stack up. Documentary evidence absolutely reigns supreme with the highest probative value. And remember, under modern rules, things like CCTV and photos count as documentary because they address the court senses. Electronic evidence? That's high, but it's conditional. It depends completely on proving its integrity. And testimonial evidence, honestly, is highly variable and usually the lowest because it's so vulnerable to human error and cross-examination.
So class, I leave you with this final bar-level hypothetical to chew on. If your absolute star witness gets on the stand and completely contradicts the clear, unambiguous terms of the original written document, which one is the court ultimately going to believe? Well, if you've been paying attention to the original document rule, parole evidence, and the hierarchy of probative value today, you already know the answer. Keep studying, always trust the documents, and I'll catch you in the next explainer.